stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome to Administrative Static. This is John Vecchione, and I'm here with Mark Chenoweth, and we have real exciting news, I think, in the world of administrative law, certainly. On Monday, the Supreme Court granted certiorari in the case of Loper Bright, and that name is a fishing company. That
is it a boat too, or no?
I believe they have a boat called that.
Okay.
But that is the first, and so this is the case. We have one like it as well in the First Circuit called Relentless, which is a boat and a company as well. And the Loper Bright was represented by cause of action for many years, all the way up till now. And Paul Clement has joined them to bring this case to the Supreme Court. And it's very exciting because this is the case where the government, the statute says that they can put monitors on the boat, all these fishing boats, to make sure they're following the fishing regulations and things like that. And the case isn't about that, though. The administrative agency, with no statutory support, said, well, we're going to charge you for those monitors that Congress says we can put on your boats. Congress hasn't said that they can do that. So, unfortunately, because of Chevron, the lower court in D.C. said, look, I think the statute's ambiguous, and under Chevron, I have to allow reasonable interpretations by the agency. So, look, the agency wins. They get to charge because it doesn't say that they can't, and they reasonably have interpreted that it can. Actually, that I'm misstating it. That's Relentless. In this case, he said it was clear that they could do this, but the D.C. Circuit then looked at it and said what I just said. The D.C. Circuit said, no, it's ambiguous, and we have to give all reasonable interpretations to the administrative agencies. This isn't a fair approach, but it's the approach that we have in Chevron. And so the D.C. Circuit says Chevron requires this outcome. So it was kind of interesting for us Supreme Court nerds, because this case was relisted. It was relisted 4 or 5 times. And that's usually, once, twice, but, that many times.
3 times, maybe.
Yeah, exactly. We think that when it's relisted that much, that maybe someone's working on dissent or something. And so, Buffington, right, was relisted a number of times. And then we got a dissent from Gorsuch of denial.
Right. Although Potium was, I guess it wasn't relisted, it was rescheduled, which
yeah.
I won't get into the weeds that far.
So so it was granted, and it was only granted on one question. Dun, dun, dun. The question is, should Chevron be discontinued or narrowed? And in this case, and that is the only question. They didn't take any of the questions of the Magnuson-Stevens Act. They didn't take anything about the APA. They just took Chevron. So the reason this is exciting and the reason this is important is that people have been trying to get a case up to the Supreme Court. Well, they'll cut back or clarify Chevron and take away this incredible agency power in any litigation. That their view of the regulation and whether it meets the statute or the Constitution even is kind of there's a huge weight put on their side in any litigation. So the court has been dodging and ducking this. They've used major questions. They've used anything not to say Chevron for about a decade, I'd say. At least 8 years, but probably a decade.
Well, and then there was the Kaiser decision that came down where they said, well, this doesn't apply to Chevron.
Right.
This just applies to our deference, which is deference to an agency's interpretation of its own regulations, whereas Chevron is to the statute.
Right. And so they did have to use the word. So, but in any event, they've been avoiding it. They're not avoiding it now. They took it on purpose. And so something's going to happen.
a couple of lower courts have called it the Lord Voldemort of Supreme Court precedents because there's been such reluctance to invoke the word.
Exactly. And in fact, in
the Supreme Court,
in the Mexican Gulf case that we had, one of the judges there did a dissent. He says, I don't know that Chevron's working anymore because the Supreme Court hasn't mentioned it in years and years. So I do think that this is going to be a big case, but is Chevron going to go away? Are they going to say this is no longer precedent and we look at the statute and regulation ab initio without any deference to the agencies? I've been reading the legal press and I've been questioned by news reporters on this issue, and I'm told that most of the people they're talking to say that Chevron's going to be overruled. I don't know if it's my pessimism or just my counting of the votes. That is a prospect devoutly to be wished, but as I look at it, I think they're going to cut it back. That's my prediction. I'm making it here. We can replay this after the case comes out sometime next year, but I think that there's too many ameliorists on the court to just get rid of it straight out. But I do think, and I think it would be very, very important.
And for those who don't share John's vocabulary, an ameliorist is someone who wants to just make something better, allegedly.
Exactly, and exactly, and do it slowly. So make a little bit of improvements. And I see enough of those people on the court that I think it would be big anyway. But it strikes me that one of the things that the government wins on in a lot of circuits, not in the Fifth Circuit, but in other circuits, is this silence when Congress doesn't say anything. There is a line in Chevron that, even silence can be ambiguous. That's in the Chevron case, which I hate.
It's the worst line in the case, probably.
It's the worst line in the case. And silence shouldn't be that. And
I agree with Judge O'Scanlan in the Ninth Circuit, who said in a dissent from rehearing en banc in a case where he's joined by like 9 other judges, he said that silence is just where Congress stops legislating.
Yeah.
Which I think is exactly right.
That is exactly it. And so here, Congress had allowed charging for these monitors. The government could force you into a contract if you were a foreign fisher, and under certain circumstances there, and then it had other programs for charging for monitors in the Northern Pacific, which is the richest fishery with the highest capital investment and king crabs. If you go to the store, take a look at what a king crab costs you, and you'll see the difference between that and a herring. But in any event, it is Congress did make laws allowing this in certain circumstances, but not in the other circumstances. And the court has therefore allowed this just because the agency wanted it, not because Congress wanted it. And that is the big problem here, because these are small boats and small companies. These are not, it's not some giant fishery outfit going out there. They are usually mom and pop. It is interesting to me that the entire herring fleet, basically, who does this, are represented by nonprofits. There's us at New Civil Liberties Alliance, and there's Cause of Action, which I was there when those clients were signed up, and they've followed this case through over 4 years, all the way up to the Supreme Court. But all of that was done pro bono.
You might say, was there a white whale?
Yeah, exactly. Well, Chevron certainly is, right?
Yeah, sure.
So they've all been represented pro bono all this time, because these are not the type of companies that can sustain these kind of legal fees that you need to go to the district court, go to the appellate courts, petition for certiorari to the Supreme Court. And so it's telling that Chevron is not just used by the agencies to, rein in big companies or do anything like that. It basically affects everyone's life who works anywhere where a regulation can touch them, because you don't get to read the statute. And one of the things that really strikes me about this case is, if you were a layman reading the statute, you would not find anywhere that you were going to be charged for these monitors. No one ever opposed it, as far as I can find. Nobody, when this was monitors being put on commercial vessels, these are commercial fishing vessels, was not opposed by the industry. But if you're a mom and pop and you're looking at this, how would anyone reading the statute think that means that you're going to be charged? And they were charged. for I think 20 years after the Magnuson-Stevenson Act was amended, Congress just appropriated the money. And they appropriated the money, and that was it until the agency decided that it wanted more of these people. And then they said, oh, now we're going to charge. So you couldn't really participate in the making of the statute by calling your congressman. And I will say this, in New England, if you're a fisherman and you call your congressman, somebody picks up the phone. Usually...
they've got a guy for that.
They got a guy for that, exactly. Because there's usually, in each of these fisheries, there's usually a congressman who's extremely interested in what the fishing industry has to say. Even if it's not a huge dollar number for him, it's a lot of these communities are historic. A lot of them are places where everybody knows that that's where you go to watch the fish come out, the fish come in, and all that.
It's like wheat farmers in Kansas or beef cattlemen in Texas or something.
Right, exactly. It's an icon of that part of the country, exactly. So Loper Bright, they're out of New Jersey. I think they're out of Cape May, actually, I think. But in any event,
nice and important.
Yes. So in any event, and I don't quote me on that, but I do think that this case is going to be a landmark case for administrative law. And I can't believe that. I also have a pet theory that I've said before, that I think that Judge Srinivasan has been citing Chevron, deciding cases on Chevron, and basically tweaking the Supreme Court to go do something. Yes, exactly. I don't think it's an accident. And so I think he had a hand in this. And the last thing is Justice Jackson heard the argument below, and she's recused herself, apparently. She didn't write an opinion or anything, but I guess
she was on the panel.
Yeah.
And
she was off.
Because she got appointed to the Supreme Court.
Right, exactly. So it's going to be 8, but it was only 6 for Chevron, so we'll see what happens. Very exciting. We'll be right back.
Welcome back to Administrative Static. Mark Chenoweth and John Vecchione with you. And John, I don't always read the New York Times, but when I read the New York Times, I'm typically disgusted with what I read. And the same was true this last week when I saw an opinion column by, I gather the gentleman's name is Jamel Bowie, a regular opinion columnist for the New York Times, who apparently doesn't know his you-know-what from his elbow when it comes to the Constitution of the United States. And he wrote this article, "The Polite Disdain of John Roberts Finds a Target," sort of an interesting, I'm not sure the title of the piece necessarily corresponds to the content of the piece.
And they don't write the headlines.
They don't write.
I always say, as people have called me to yell at me about that.
That's right. So I'll focus my disdain on the content of the piece. First of all, he starts off by saying, it is true that the branches share powers and responsibilities. No, Mr. Bowie, it is not true that the branches share powers and responsibilities. The whole point is to divide the powers and responsibilities across the different branches of government. That's what the separation of powers means. That's what the separation of powers is about. Now, if you want to suggest that there are some, that in actuality right now, there are some powers that are shared across the branches, I would agree with that. That happens. I think a lot of that's unconstitutional. And there may be some at the margins ability to have some sorts of things be shared, but that's not the way to start off thinking about it. The 3, Article 1 establishes the legislature, Article 2 establishes the executive branch, Article 3 establishes the federal judiciary, and never the, what would it be, thrain? Never the thrain shall meet.
Yes, exactly.
Would be a better way to think about it from a constitutional standpoint. But what has Mr. Bowie's shorts it a bunch is that the Senate, in the personage of Dick Durbin, I guess my former senator when I lived in Illinois for a few years, has called upon Chief Justice Roberts of the Supreme Court to come and testify on Capitol Hill about some sort of new ethics policy or ethics rules that would apply.
They want a bill.
They want a bill. They want a law. And one of the things that also comes out of the Constitution is that the branches of the government are largely self-policing. Now, that doesn't mean that, for example, a member of Congress couldn't be indicted and brought for charges in front of a federal court. Of course, they could. But you won't see the Chief Justice of the United States writing the rules that govern the Congress of the United States and the ethics rules of Congress, for example. But now Congress does want to turn around and write the ethics rules for the Chief Justice and for the other members of the Supreme Court. Well, that would be a problem in terms of the separation of powers. And I do think that that Chief Justice Roberts, who I have been known to criticize occasionally on this program, did the right thing here by declining to answer. I also think it's a little bit rich, John, for a politician who hails from Chicago, Illinois, to be lecturing anyone else on ethics.
Well, the thing about it is, the other thing is the timing. The court has been extremely slow in getting out opinions. They wanted him to come before June.
That's a good point.
And there was an ethics hearing before Congress that just happened this week, and it was a circus of look, they don't like that these folks got appointed, and they are now trying to besmirch the reputation of the court, particularly the conservative justices, where they're making
I think exclusively the conservative justices.
They're making up new rules only for them that they've never applied to anybody else. And I don't think he wanted to be part of that circus, and I think he's perfectly within his rights to say no. The president, Congress calls the president, he does not have to come, right?
That's right.
It has to do with the three branches that you're talking about. And
Chief Justice Roberts is not the Chief Justice of the Supreme Court. He's the Chief Justice of the United States.
Yep.
He is the head of the entire judicial branch.
That's right. And so he goes once a year, he does go before Congress to talk about money. All right. What does the judiciary need? And what they've threatened him with here is $10 million. And in this hearing, it was brought out. I forget which senator brought it out. The exact amount that they've asked for more security, because security needs have gone up at the court since the leaking of the Dobbs decision. And they've had assassination attempts. They've asked for more money so that they can protect the justices from being assassinated. And Durbin threatened to hold up that amount of money if he didn't come in. I don't think that's going to happen, but that shows you what's going on here, because that is terrible.
It's terrible. It's really unconscionable. The idea that you would play games with justices' lives in order to make a political point. And, I saw Senator Kennedy rip into Senator Schumer in a hearing this week where he reminded us that Senator Schumer was on the steps of the Supreme Court saying Gorsuch, and he didn't say Justice Gorsuch, saying Gorsuch, Kavanaugh. Again, he doesn't say Justice Kavanaugh. You've reaped the whirlwind. You don't know what you've asked for. And Kennedy's point was, is this what Senator Schumer meant by that they're going to start allowing this kind of treatment of the justices? It's awfully shabby, and I think that the Chief Justice acquitted himself very well by respectfully declining the invitation.
And attached to that letter was their ethics rules that they bind themselves to, and they all follow. And it was on behalf of all 9. There was no dissent. Nobody said, I'm not in here. They said, here are our rules, and all the justices were there. So I think that...
Yeah, I did see Justice Sotomayor, Justice Kagan raising their hand, volunteering to come in his place.
Right, and or saying that anything was wrong with their ethics protocols that they've all laid out and all agreed to.
Yeah. Well, some of these articles have been really terrible, particularly the one about Justice Gorsuch and the sale of real estate property in Colorado, which he did disclose and which was sold at well, I don't know if it was at a loss, but it was certainly for less than they originally had listed the property for. It was sold to a major Democrat donor, et cetera. I mean, there's no there, and yet they tried to make it out like there was some
right. And they never met. It was through an LLC, so it wasn't. And he when they closed the LLC because they sold it, he reported it. So it is a drumbeat, and it's being done. I see Dan McLaughlin says that it's a planned rollout the way this is going on. And I have to say, there's a lot of evidence of that.
Oh yeah, I think there's a lot of evidence of that. In part because they're dragging up things that are old news with some of this, and they are only going after the Republicans, even though folks have pointed out Justice Jackson had to restate some of her things on her ethics forms within a couple of days after getting appointed to the Supreme Court by the White House. Justice Ginsburg had done some of the same sorts of travel kinds of things and wasn't.
And something was wrong with that. That's what you do. You find an error, and a couple days later you change it, and you shouldn't be excoriated for that. That's what they're supposed to do, and yet that's what they're complaining about. It's very unfair that they're doing it to one side. And by mentioning Jackson and I don't think she did anything wrong either.
Yeah, I'm not suggesting she did for sure, but I am suggesting that Jamel Bowie doesn't know what he's talking about, because he says that separation of powers in Roberts' view means that the court is outside the system of checks and balances that governs the other branches of government. Come on, that is not what his refusal to appear at a circus hearing in the middle of the high season for the Supreme Court to get its work done means. It's a silly viewpoint, and I think that the readers of the New York Times are yet again being misled by illogical opinion pieces on its pages. And I wish that rather than participate in this rollout that Vec just referred to, I wish people would stop and think, including opinion journalists at the New York Times, and recognize what would happen if Congress had control of the ethics rules for the Supreme Court. Well, for starters, you think that they wouldn't write ethics rules that went after particular justices or went after particular practices? Or of course they would.
It's worse than that. The proposals are that anyone can file limitless amounts of ethics violations. Anyone in the country, and that then the heads of each of the circuits then is required to investigate it. No matter what the allegation is, those judges will then have to investigate it. What investigatory powers are they going to have, right? And some proposals are that the executive will do it, which is even worse attacks on the justices, right?
Oh, yes.
So anyone can make a complaint. It has to be investigated, and of course, some other branch is doing it. I mean, can you imagine what is the independence of the judiciary going to be after that?
Right, and who's going to want to serve? I mean. We've seen this sort of thing play out before, where you have the endless ethics investigations. John, I think maybe in the IG context, we've seen this happen.
Exactly right.
It's a strategy to prevent someone from doing their job. This was done to Governor Palin when she was the governor of Alaska. Just endless ethics complaints, mostly bogus, maybe entirely bogus, trying to derail someone's ability to actually focus on their job. And that's what would happen here. And that's why it's right for Chief Justice Roberts to say no. You can't have a world in which the Congress is leading the judiciary, whether it's the Supreme Court or other federal judges, around by the nose like that, because that would, as John just intimated, that would get rid of the independence of the judiciary, or certainly hamper it substantially. And the justices wouldn't be able to do the job that they have been appointed to do. And if Congress has a problem with a justice, impeach him. Impeach him in the House and convict him in the Senate, because that is the system the Constitution set up. And if you want to talk to us about the Constitution, Mr. Bowie, I recommend that you go read the portion about impeachment and removal, because that process is there. Use it if you need to. Otherwise, leave Chief Justice Roberts alone.
And I'll just add before we go, they've impeached other judges.
They have.